Hey folks, I'm Jeff Seville, Executive Director here at CEI, and welcome to our second episode of Smartboard Tuesdays. I have a very special guest today, Ron Kisicki from Woods Oviatt, and Ron was our Mentor of the Year last year, and has been a very special person to our programs here at NASET and at CEI, and we're happy to have him in our facility now, and we're going to talk about some new rules coming up for patents and filings of patents and so forth. So Ron, take it away.
Okay, well thank you, Jeff. I set up a scenario on this on the board. What I have is two inventors. I have inventor number one, who invents a widget that has features A, B, and C. And the second line below the first line is inventor two, who invents the same widget containing features A, B, and C. Focusing on the inventor number one, you'll see that he progresses to the right to the point where he files at this point. Looking again at inventor number two line, you'll see a situation where inventor number two filed at this point, and it occurs prior to the time of filing of inventor number one. In that situation, since we are first to invent country, it does not tell the full story. Looking at this, we have a situation where inventor number two got to the patent office first, filed for the same invention, and the question is, does it leave the inventor number one out in the cold because he filed after? The answer to that is we look again at the timeline number one, is that we have to look to determine when inventor one actually invented the widget containing A, B, and C. According to my timeline, you'll see a first event. It's called conception, and that is a date on which the inventor number one would have conceived the idea in his head, not necessarily building any prototypes, but conceived the idea pretty much as it's going to be claimed in the patent itself. The actual date of invention occurs after that point.
So are they filing some lab notebooks at this point? Or are they documenting things before they actually get to date?
This would be the start of the lab notebook. This would be the point at which the inventor starts to draw sketches, starts to maybe write in paragraph form what the invention is trying to do, how it performs. In order for inventor number one to claim that invention, because at this point, because he was first to file, he's regarded as a senior inventor. Inventor number one now has to do something in order to demonstrate that he indeed invented first, including that the inventor did not abandon, suppress, or conceal the invention. And there's also a period of diligence that has to occur between the time the inventor number two filed and the time inventor number one filed.
So how is this all going to change?
The way it's going to change is that, like the rest of the world, and it's being done to commonize the U.S. law with the rest of the world. What's going to happen is all of this activity prior to this file date would be of no consequence. So if in determining whether inventor number one can actually get a patent, they would look just strictly to the date of file. In this case, since regardless of what he did before, since this date occurs after this date, inventor number two would be awarded the patent.
Is this going to change a lot of...
No, it will not. And the reason for that, and it's sole inventors or individual inventors may get excited about this because they believe it puts them on a even playing field. In fact, it doesn't. The senior party 90% of the time wins. And it's simply because they cannot carry the burden of proof to show.
I'm assuming that's a very expensive process to prove that as well. Yeah.
It's a formal litigation before the patent office, and you know, the cost of it is, as you might guess, the cost of an attorney. You know, churning the
doggone attorneys, Ron. So go ahead and give your firm a plug.
Okay, I work Woods Oviatt. That's my firm. I have my phone number up there. I encourage anyone listening, if you have any questions about what I presented today or about the new law, the new patent law that's coming into play coming up in by April, and a lot of it has already been implemented.
Yeah.
If you have any questions about that, questions about trademark law, questions about copyright law, give me a call.
Excellent. Excellent. Ron's really open. He means that by giving him a call, he'll help you out as well. So thank you, Ron, for being a part of our second episode of Smartboard Tuesdays, and we're going to keep doing these. We'll post them every Tuesday, and be sure to check out CEIgateway.com for all our events that we're having here. We have tons of lunch and learns, some really good topics, and again, we're going to have lots more episodes of Smartboard Tuesday, so I'm going to go ahead and give it a good scan here, and we'll have this image of Ron's artwork here up on above the video when we post this on Tuesday. Thanks, everybody.